Welcome back to the Weekly Friedman, your source to the most essential information in the default industry. Foreclosure actions are generally considered straightforward actions. A debt is owed, it's secured by a mortgage, and the holder of the debt forecloses and compels the sale of a mortgage premises. And in most cases, it really is that straightforward, but sometimes it's not. Today, we're going to be discussing a case, Hassan v. Theophile, a Union County, New Jersey matter that involves a foreclosure that was anything but straightforward. I'm Adam Friedman, managing partner at Friedman Vartolo, and today I'm joined by Friedman Vartolo associate Renee Cohen. Renee touched this case while at two different prior firms, and she has extensive experience navigating extremely complex New Jersey foreclosure matters involving a wide range of title issues. Your first time on the Weekly Friedman. How's everything going?
Thanks, Adam. Thanks for having me. Thank you for the great introduction. Everything's going well. Foreclosures can be definitely complicated. Most of the time, though, it's straightforward. In the Hassan versus Theophile case you mentioned, it did involve 18 different properties, not just one foreclosure. So all those were actually either in foreclosure or in default at some stage of the process.
So what does that mean? So there were 18 different mortgages and like 18 different separate loans, or was it one mortgage covering all the different properties?
That's correct. There was 18 different mortgages, 18 different loans, and also not all of them were with the same lender. So there was several different lenders as well.
Okay, so you want to walk us through I know there's a lot here. I think the decision that I read was dozens and dozens of pages. What are the most important facts, though, in this case?
So basically what happens is when you get a foreclosure case, you review the title. And in this case, there was a prior owner of these 18 different properties. It was an entity, an LLC. And that prior owner contested the transfer to the current owner, who then took out the mortgages on the 18 different properties. They said that was a fraudulent transfer and there was no authority for the guarantor and the member of the new entity to take out those mortgages and to transfer the deeds.
Okay, so just to recap, there was an owner of 18 properties. I believe there were some dealings with that owner and then a new owner, right? They had some relationship. The new owner transfers them into his name, gets 18 different mortgages. And then again, as you just said, the basis of the suit was challenging that entire transfer. That makes sense?
That's correct. And it's important to note that this suit was a quiet title action, not a foreclosure action.
Was the prior owner just saying these deeds were stolen from me? Like what was the basis of this lawsuit? Like what was their legal justification?
So basically he had said they were business partners, Hassan and Theophile. It was almost an oral agreement, it seemed like, for the most part. Eventually, there was a written business partnership agreement. However, most of the dealings that they had were verbally. And Hassan wanted to take a mortgage out on these 18 different properties. However, due to some judgments he was unable to get favorable terms. So he had asked Theophile to assist with him in one, registering his LLC in New Jersey, and then two, getting loans. Theophile had many different properties. I think he had 108 different properties in New Jersey. So he was very familiar with getting commercial loans on different properties. So he said, oh yeah, I could help with that. In exchange, he was going to get some fee for it. And during the course of those transactions, it came to light that he was unable to get a loan on the properties without transferring to a different entity because of those prior, at least favorable terms, because of those prior judgments that Hassan had. And so Hassan said, yes, do what you need to do to Theophile, at least it's alleged. And then Theophile was able to then obtain the 18 different mortgages with the new entity's name.
Your explanation sounds reasonable. So we're saying Hassan, the original owner, nothing was held individually, it was through companies, but for simplicity purposes, Hassan was the original owner. Hassan says, sure, transferred into Theophile's name or an entity held at least in part by Theophile and Hassan, and then get the mortgages. Theophile then gets the mortgages, right? Why did Hassan, at least your explanation sounds reasonable. Like, what is Hassan's justification for unwinding this transfer?
Some time later during the course of their transactions, it was going to be a 50-50 split with the properties and according to the case. However, sometime Afterwards, Theophile decided he didn't want to have anything to do with the properties and wanted Hassan to take back over basically 100% control. And at that point, and Theophile stopped paying the mortgages on those loans, there were several foreclosure cases that were filed against Theophile and his entity. And that is when I believe that Hassan got wind of this and that they kind of fell out. Their relationship fell out and things were in default. They were like, no, I didn't give you permission to transfer it. And I want to declare these mortgages as void.
Okay, so you mentioned that the mortgages themselves went into foreclosure. So how did this quiet title case impact those foreclosure actions?
There was a motion to intervene in most, if not all, of the foreclosures by Hassan and his entity into the foreclosures. That was ultimately denied after several briefings. And then the court had said, well, yes, if Hassan, what he's alleging is accurate and Theophile did not have the right to transfer the properties and obtain the mortgages, then the mortgage that you're foreclosing is void. And so you can't foreclose. So what they did was they stayed all of those foreclosures pending the outcome of this quiet title. So at that time, the lenders who were plaintiffs in the foreclosures became defendants into the quiet title. And they asserted counterclaims and cross-claims in that for equitable mortgage, equitable subrogation, and fraud against Theophile for if Hassan was correct.
So what was the final result in the quiet title action?
So the final result was that the court did not believe Hassan. They found his testimony to not be credible, and they believed Theophile when he said that he was acting with authority to transfer the properties and to obtain the mortgages. So they said, the 18 properties are in the new entity's name and that he had authority to do that. He had authority to take out the mortgages and their first liens on the property. And so the equitable mortgage claim and the equitable subrogation claims, those were moot. And as to fraud against Theophile, because they found that he wasn't acting with fraudulent intent, denied that claim as well. And then they lifted the stay. There was then filings in the foreclosure action to lift the stay based on the quiet title final judgment.
So obviously this is an extreme situation, right? We have 18 different mortgages, 18 different properties, allegations of fraud and a million other causes of action. It's clear that this doesn't happen every day. But do you find that foreclosure actions are generally straightforward, or do you normally see or regularly see these types of weird title issues that kind of entwine themselves in the foreclosure action?
No, I think most foreclosure actions are pretty straightforward. You have one borrower or two borrowers. You have the same owner of the property. There's not a million transfers, especially in residential foreclosures. You're not going back and forth. It's a little bit more so in commercial foreclosures where you're going back and forth between entities. But they're still usually pretty straightforward. And usually you could get around with filing a title claim, you get a letter of indemnity, and nobody contests anything, and you go to sale.
All right, so to recap, most foreclosure actions are relatively straightforward, involving a foreclosing plaintiff, a mortgagor, and other necessary parties. Certain actions, like the one we just reviewed, can become incredibly complex, and you generally see this when different title issues arise. Thanks for joining Renee Cohen and I on the Weekly Friedman, your source for the most essential information in the default industry. Looking forward to seeing you next time, and thanks for tuning in.